So they'll say, we expect this is we expect that this is going to cost us $5,000 or whatever the amount is in order to comply with discovery. And they ask for payment for that up front as a retainer. So I've seen that.
Hey, Carl, I'm trying to think through this. We're talking about putting this provision in a contract or an agreement that might be executed today, but the caveat proceeding might not occur until 10 years. And so
30 years. Right.
And the executors might have changed over the course of time. I guess, the who's listed as the executor initially, I guess that could change over time, I guess.
Sure.
But why would this not generate more litigation with respect to whether or not some future executor or some bank, for example, says this provision is unreasonable, it's unconscionable, et cetera, et cetera. And quite frankly, it's ambiguous because who's going to know what the prevailing attorney rate is going to be 10 years from now? If I sign that today, I will be paid in the future at my then prevailing rate.
Right.
How is that not ambiguous?
I don't know that I know that's a fair question. I don't know that I know the answer. I would say that I think that that's as a matter of evidence to say that what an attorney's prevailing rate is. I mean, I charge the same thing for everybody. I don't have a different rate if I'm appearing in court. I don't have a different rate if I'm administering a state. I suppose I have a different rate if I'm doing pro bono work. That's zero. But so I think that maybe there's an attorney that's being that would be 10 years later, right, be trying to be opportunistic and charge an excessive rate. But that would be, I don't know, that would, I wouldn't lose sleep over that. I thought you were going a different direction. I absolutely have a problem. And I realize I'm challenging, attorneys at AgTech, but some of these provisions seem to be really broad. And in a situation where it's perhaps the drafting attorney himself or herself who has created the problem that generates the caveat. In fact, it could even be the result of the caveat proceeding itself, how it goes, whether a will is set aside or not. Mm-hmm. The idea that lawyer would be himself being compensated or reimbursed for his own generates the caveat. In fact, it could even be the result of the caveat proceeding itself, how it goes, whether a will is set aside or not.
Suzanne, I think you put yourself on mute.
Suzanne, I think we may be getting feedback from the live stream.
Yeah, I'm trying to figure that out.
It's gone away now. And so I think what Carl has said is obviously there's a concern that a lawyer who's providing testimony within the caveat may actually be responsible for the error. And I agree. I think that's the area where this makes this the most difficult sort of issue. Before we go there, because I think that's an important area, I would like to see if we can sort of complete this one thought around whether or not an agreement could memorialize the rule about what a witness is allowed to recover if they testify under the situation that Carl just described, where the witness was called by the executor. And Marcy, you had come off mute. I didn't know if you had a comment.
I was just wondering if the retainer agreement said that the hourly rate would be X and you put whatever that rate's going to be and not leave it to some future, what my prevailing rate is at the time, if that would take, it was just a thought. I don't know. So if you
I guess a comment I would make about that's challenging is we regularly represent clients where their estates don't materialize. And I know Todd mentioned 10 years. It's regular that happens for 30 years. I've been in practice for 25, and there are lots of clients. And I would say I would have had no idea when I was a first-year associate in 1998, what my prevailing rate would be today.
I understand that.
Probably would have been shocked by that.
I totally understand that. I'm just saying that the problem is that it's too vague. You don't know what it's going to be like in 10 or 30 years. To take care of that, you put a max of no more than X number of dollars per hour. You just have to put it in your retainer. Then that takes care of the problem with it being too vague. Yeah, well, is the lawyer who's doing the estate work selling themselves short because they're going to get paid less per hour than they would get paid at their prevailing rate? Maybe, but then what they get in exchange is, if what Martin is saying is true, and that if there's some document that would give them some, I want to call it priority, legal priority, but at least in the clerk's mind, some priority, then maybe that's the trade-off. I'm just, again, I'm not an estate lawyer. I'm just a thought.
I mean, I think it can be argued that when you're pulled into one of those cases where other people are fighting about a collateral matter, you want to do as little as possible. I mean, you want to try to get away from that. And I don't know whether there might be some positive protection for clients to say that attorneys are going to be paid their fair rate. I just don't think that's something that's hard to prove. Maybe I'm wrong about that,
but we're also dealing with people that they're doing this estate plan, and it is their desire that this plan be carried out. It is their wish.
Right.
It's really not the wish of the executor or the whoever ends up doing it. I mean, the person who owns the assets, they're doing their plan, and they want to make sure that their plan is carried out. So
Marcy, I agree. I will tell you, I'll tell you a real case that is no longer in our office, but was in our office in a situation like this. So unsurprisingly, the clients were living here, moved to Florida, right? And so they have a North Carolina will that, because of the full faith and credit clause of the Constitution, Florida is going to honor that will. But there's a Florida probate proceeding going on, and then a collateral dispute proceeding going on in Florida, which has to do with different laws entirely. And now lawyers are getting subpoenaed at our cost to go down, to fly to Florida, to spend time overnight, to when it cancels out, to fly back, and so forth. It can be really problematic. And so it's yes, you want to see the work that you've done honored, for sure. And we're professionals. We're not doing, as a general matter, we're not doing that for free, right? We want to see it honored. We want to see the plan go through. But my point is, it can be extraordinarily complex, where you're being pulled away from your practice for days on end to different states. That's the reality of how that works.
So
Hey,
Carl, as one action item, could we get from you after the meeting that language that currently exists about the occurrence witness?
I don't know that language exists. I think that's language that, and Suzanne and I know exchanged an email about that. I think it's in the litigation, and I'm more of a planner than a litigator. I introduced myself at the beginning. So I do think there's language about how fact witnesses in cases are reimbursed.
Okay. Martin, do you have that?
No, are you talking about that from the estate situation, or are you talking about that in general litigation?
I think it's in any general litigation.
So that may be what you're speaking of when you talk about the medical field having an agreement, like for malpractice, whenever you have, doctors, because I was thinking about that earlier as well. Doctors get pulled in all the time to give fact testimony about the condition, and they get paid to do that, even though it's facts, and they're providing professional opinions about whether it's causally related or not. And, when we're getting pulled into this kind of stuff, and I did a mediation on Monday I've got a new wrinkle to this when we get a chance. It's really kind of weird, involving a declaratory judgment action. But when we get pulled into this to have to sit and do it exactly as you're saying, Carl, it could take days to go through, even though there may not be a good faith basis for the caveat, but it's a shakedown that's occurring, which is not unusual at all. There was one filed for, and y'all will all know exactly who this is. It was filed 2 days before the statute ran, for a former state senator that just occurred in Columbus County. And so that's being caveated now. So there's going to be a new caveat proceeding that's going to go on down here. It's going to be fascinating. But when that happens, you got to stop what you're doing. You've got to go get the file. You've got to appear. You've got to do this. And maybe it just goes to the situation with regard to the clerk being kind of like or even the superior court judge, because you can't appeal the clerk's ruling as being the gatekeeper for what's a reasonable fee. And
Marcy, one thing that Martin's saying that I think is pertinent is this happens all the time in the medical field. I don't think they have a particular set fee. There's just a judicial determination of what the prevailing fee is for that doctor in a med malpractice.
I guess I was confused because I thought you were saying, well, we can't do this because it's too vague. Or maybe Todd was referring.
I think Todd was suggesting that.
Yeah, and so I'm
I think
thinking,
the
well,
problem isn't really 1.5, and I realize that that's important. We don't want to, no one wants to fleece clients. But yeah, I don't think the problem is really in 1.5 respectfully, and we certainly could add things to help tighten it down.
Hey,
I think
Mark,
the concerns are more largely, is somebody getting paid to defend themselves,
Right.
or what will end up defending themselves. I think there's potential for conflict here.
well, I think we all agree that if you are defending, if you're being accused of malpractice, that you shouldn't get your
fees
fees.
paid. Right.
But I think, Marcy, the
We
issue
all
is,
agree to that.
yeah, but I think the issue is there's not a measurement of the malpractice claim. You don't even know whether malpractice has been committed until the will is or isn't
That's
set
right.
aside.
Oh, okay.
Right.
It's
That's
a
exactly
timing
right.
thing, timing thing.
And
And
even then,
oh.
we're not medical. We don't know when someone comes to see me and they appear to be oriented, time, person, and place, and we do an estate plan and put it in place, and then suddenly John, who got cut out, whereas Susie and Bob don't, suddenly John's very upset and wants to say, well, you should have known better. And we're like, well, wait a minute. I mean, he could tell me, he could recite up and down the Pledge of Allegiance. He counted backwards from 1,000. I mean, whatever it is, it didn't miss. It's really hard and I can see why the chilling effect would occur if we can't get paid to have to be pulled in.
Well, I guess I want to clarify. So I understand that as we're describing, this, I feel like we all agree and we've seen that this is a problem for estate planning practitioners, drafters. They're getting pulled into these things. It's taken up a lot of time. The ordinary course currently, a lawyer that gets pulled in, like you were describing, Carl, or like you were describing, Martin, is going to have to comply with a subpoena, respond to any sort of requests that are basically duly served on them, whatever it might be. And after the fact, they can apply to the estate for reimbursement of their fees, of their time, their expenses, things of that nature. That's going to have to go through the court proceeding, or get through not necessarily the court proceeding, but it needs to get approved by the clerk, or maybe it's going to get challenged by the clerk. But there may be some uncertainty, but there is a current process by which a lawyer who has to get pulled in and spend a lot of time can apply for reimbursement of the expenses experienced. This provision would then not, I guess that's what I'm trying to figure out, the effect, the practical effect.
That's right.
This provision does put the lawyer in potentially the same spot, unchanged, or it might be that this provision effectively gives that lawyer a priority placement to some people, as to some executors, like you were saying, Martin. As an executor, you might be looking at this thing and say, well, I've got a contract here, so I'm going to pay this one first. We're going to classify it as an administrative cost or whatever it might be. So they're going to be a priority 0 expense. And it basically, it heightens the lawyer's ability to get repaid. And I know we can get into is that beneficial to the client, the testator, because the lawyer has, I guess maybe that's a question. Does the lawyer have more of an incentive to participate because they have a priority position, or at least they're hoping they'll have a priority position? Is that an incentive that does not need to exist because a lawyer is going to respond to a subpoena fully and honestly, just whether they have a priority position or not? And maybe that's a question of the message that it sends. But I want to make sure that maybe we're all on the same page, in particular that I'm understanding this new provision that we're discussing is something that has the effect of potentially putting the person in a priority position, even though there's currently a process in place by which they can apply for reimbursement. Am I correct in understanding that?
I think that's fair. I mean, as a practical matter, I think that's fair. Okay. Yeah, I think you are part of the administration of an estate. It's almost like a guarantee that a decedent has in place. That's a contractual obligation that's required to be met by an executor after death, even though they entered into it during their lifetime. So it becomes an administrative expense of the estate rather than a general creditor of the estate.
Okay. Hey, Carl and Martin, let me ask this question. I know 621(2) addresses costs paid in caveat proceedings. That's statute 6-21 section 2 specifically says, costs shall be taxed against the parties in caveat proceedings.
Mhm.
And obviously 6-21, and I've litigated it, can include attorney's fees.
Mhm.
So to Brian's point, isn't there and the person who would be the subpoenaed party himself or herself goes to the court and makes this request, or does the party that subpoenaed that witness go to the court and ask for the reimbursement of fees to comply with the subpoena? I mean, how does 621-2 impact what we're talking about? Seems to me that it might already be in place. The statute, for some reason, carved out caveats to wills, and it talks about being taxed against either party. Whereas that same provision, 620-21, you family lawyers will know this. Section 4 carves out actions for divorce and alimony, and it says there the judge can tax the cost against the estate. I mean, so the statute specifically carves out when you can tax the estate. Section 2, as to caveats, does not say that. I mean, so how does that work in practice, if at all?
What I've seen, we've used that for is kind of a sword and shield situation, or a carrot and stick. If you do this and you file this caveat wrongfully, we're going to request that the court not award your attorney fees, and that you have to, and the portion of attorney fees that we have would come out of your share. And so you use it kind of as a leverage. That's the practical matters. That's what we do before. I've actually had a hearing before where I had an individual and it was not a caveat proceeding, but it was just a disgruntled heir, and he wouldn't stop. He kept filing things with the court, and we finally had a hearing on him, and I was able to reduce the amount of the court was reduced the amount at my request of his inheritance based upon spurless actions that he had done in the estate, the filings he had done. So that's where I've seen it used there. And I've seen it in, normally when we have caveats, the court has to find there was like a good faith basis for it, which is not a very high standard, and then everybody gets paid as far as the attorneys go.
I'm just talking about the language which says the cost shall be taxed against the party. It doesn't say taxed against the estate, and we're talking about a situation where these costs may be taxed against the estate, if I understand it.
Let me pull that.
I mean, it says it shall be taxed against either party at the discretion of the
It
court.
says nothing about estate. If you look at section 4, it carves out estates. So
Right.
that
Well, so a state typically is a party to a caveat proceeding, but yeah.
exactly. So this doesn't apply in your view. Section 621-2 doesn't apply at all to what we're talking about.
No, I think it could apply to what we're talking about. I do think that caveat proceedings are one of many kinds of challenges that can arise in the trust and estates world.
Right.
I
get
think
that.
that's an important point. And Suzanne, we talked about that too, is that my understanding is these provisions are showing up across the country, are showing up in attorneys' fee agreements. And those fee, I mean, there's nothing here that talks about a caveat, right? So if there's like my firm, we've got M&A attorneys, we've got real estate attorneys. If a real estate attorney was pulled into a divorce proceeding, right, that's a collateral proceeding for which deposition and so forth would be required. Or after a M&A transaction, if there's a disgruntled purchaser who's bringing a claim and drags one of the attorneys that's involved in the M&A proceeding into court, that would include this too. I realize this is arising, I think, with the request perhaps, and maybe the facts of your case, it's arising as an estate proceeding. And I'm happy to participate in that part of the conversation. I'm just observing that it's much broader, both in the estate world. And if we're challenging the validity or construction of a trust, for instance, that in some ways trusts are typically where the action is, where the money is, not estate caveats necessarily.
Section 2 applies to wills and any trust. I mean, it applies to all of those things we're talking about. It's broad enough to apply to every single estate type issue, so it seems to me.
But my understanding is that this provision or something similar is being used in other practices, completely different practices, bankruptcies.
What provision? What provision, Suzanne? I'm sorry.
A provision similar to this that says, it doesn't say the estate is going to pay. It's going to say, client, if I get subpoenaed in the future for anything related to this, you agree to pay my fees and expenses.
You or your estate, but
If
the
you're-
estate might be reimbursing a fee, not a caveat proceeding. I think caveat proceedings are particularly problematic, but not in a caveat proceeding, but because of some representation in an M&A transaction.
Did you say 6-21.2?
Yeah.
I think I got confused by that too, Martin. It's 621.
6-21, section 2.
Okay, yeah, 'cause I was
Paren two,
gonna-
not
okay.
point
Whew.
2 has to do with notes.
Yeah, that's notes and I was like, oh, that's not it. Okay.
And I didn't know that. I was trying to find it too while he was talking.
But I'm just wondering, we've talked about whether this should be limited to estate planning, but it seems like lawyers are already using this type of provision for future fees if they get subpoenaed in other areas. So the difference here is that the client is deceased, but there's the estate now. But how would you guys feel about it if it wasn't an estate planning contract, if it was a different contract, like mergers and acquisitions that had a provision that said, if we get subpoenaed later, you agree to pay our legal fees?
That's under 6-21.6 now, isn't it? Business contracts.
So that's already in there too?
There's allowance for that now. For the winner, the loser pays.
Martin, what is the provision?
Yeah, I'm not
It's
seeing it.
hold on, I think it's 6-21. Is it 0.5 or -5, 0.5 or 0.6? Hold on, I'll find it for you.
Okay, thank you.
0.5 rather than paren 5 in
Yep.
main
If you
6.
find it and want to share it, I don't know if you know how to do share screen, you can do that and can look at
Let
it.
me look. That's no, that's 0.5 is the non-justiciable. I think it's 0.6. It's a relatively new provision within the past 5 to 6 years. Let me find it for you, then I'll see if I can't share it. No, bear with me just a moment. I found it, then it kicked me out. 6.
I just put it in the chat if everybody wants to take a look at that. That's 6-21.6. I think this is
Yeah,
that
business contracts.
question. Yeah, I think this is the question that we're kind of hovering around. It's almost like, we see that there are statutory avenues for lawyers who are pulled into these subsequent proceedings to seek reimbursement, whether it's their fees, their actual costs. And so the having the existence of a contract where the lawyer, kind of makes a condition, I will provide services if you sign this contract, and the contract includes that you're going to be paying my fees if this gets challenged, whether valid or not. If I have to spend my time on it, then I'm getting paid. And we can the difficulty, I'm going to go or not even touch the difficulty of excluding malpractice or even alleged malpractice or something that the lawyer did that doesn't rise to the level of malpractice but is still the subject of the dispute. Even kind of going past that very messy issue, I guess I feel like we're kind of floating around the principle, the question of is it okay, is it permissible under the rules of professional conduct for a lawyer to include that provision to oblige the client in that regard? Is that something that, I don't know. I mean, I don't want to get terribly broad here, but I think we have to realistically look at what's the perception of the public? How does this protect the public? What is the perception of the profession if those clauses go in and are then used to recover fees when there are statutory provisions? These provisions, essentially, the new fee agreement provisions would hopefully, I guess they serve to give the attorney a better standing to recover fees. That's my general understanding, and I think that's kind of a principled question that we have to answer here.
Can I just say,
Maybe I'm wrong about that.
Yeah, Marcy, then Martin.
I was just saying, you also have to think about the person this is their will and they want it upheld, so they're the public too.
Yep.
And also, I think, you could say that whatever fee has got to satisfy 1.5. I mean, it can't be clearly excessive. I mean, so
Marcy, for what it's worth, I'm looking at a provision that says So it's not confined to, it looks almost like the Act Tech provision, so they're getting it from somewhere. And it says, person call, so without limiting the foregoing, if a professional of the firm or person rendering services to the firm is deposed or called to testify or required to respond in discovery, in the context of legal proceedings concerning any matter related to services provided by the firm. Doesn't talk about estate planning. So it's any matter. And then the bottom of that, to your point, Marcy, says, this paragraph shall comply specifically with rules 1.5 and 3.4 of the rules of professional conduct, and shall be amended as necessary to do so.
So what are you reading from? I'm sorry, I'm
just reading from another law firm's
okay.
statement.
That is not an estate planning document.
Yeah, that's what I was gonna ask, right? Yeah, okay.
Brian, what about this situation? And this is what makes me comfortable. And I think, I think you're hitting, we are circling around this same thing. As an estate planning lawyer, I want a priority. If I get pulled in, by having something, by saying, look, if I get pulled in, then you at least treat me as an administrative cost, subject to the clerk approving the fee. It's not malpractice situation. Of course, we won't really know that until the end of the proceeding. But to the extent it can be approved for as administrative, then I feel a lot more comfortable than I'm not sitting with all the bottom creditors or the heirs hoping that something shakes down the bottom for me.
Martin, I agree with that concern. I think that's the thing that, lawyers, the last thing that we want to see is estate planning lawyers jack up their rates because of the reality that caveat proceedings and any other collateral attacks are presenting themselves. I mean, it's we see there's an increase. I think that's something that has been commonly referenced in our different discussions, and so it's kind of trying to figure out what is it the cost of doing business? Do you get the priority position as an administrative cost, and how do you exclude just even the challenge where we're not going to say at the very end it's malpractice, no, you don't get to invoke this fee, but the challenge is due to, let's just say, not great drafting. There's ambiguity on the term, and we're not going to call it malpractice such that lawyers mutual is involved, but it's here because somebody is reading it wrong. And I don't know how often that happens. I don't draft wills, so that's
normally a caveat only comes into play when they're questioning the mental competence, not the drafting.
Right.
The drafting is really
clear. That's true.
It's only whether was there undue influence, was there incompetence. You don't normally get a situation when you're talking about what you're talking about is what I was saying. There's another situation where you have now a declaratory judgment action filed by two heirs against a third heir to interpret what exactly mom meant in her will. And then the scrivener didn't make a good job of doing it, or maybe they did. The one I just had I mediated on this past Monday, it's filed. So just to that extent, it's a sister brother versus actually the slayer's grandson. When grandma, this is bizarre, but grandma lives longer than her deceased son who was killed by her grandson. And the declaratory judgment came up to say, okay, well, does the slayer's son get to step into his dad's shoes to take through the anti-lapse statute because grandma didn't bother to do a will? And it's only about a $13 million estate.
Oh my God.
Jeez. Well, for all the law students watching on YouTube, you can submit your answers.
Oh no, got it settled. I settled it for them.
So I'd like to go back to the question of the caveat, if I could, because Carl said it earlier. I think we all know it, that the caveat presents a particularly thorny area because, as Martin said, it's almost always a question of the competency of the testator. And so oftentimes, and this was in my experience as well, there may not, for example, be a lawsuit against like the lawyer, like a negligence lawsuit, before there's a caveat proceeding, because the caveat proceeding is where all of that evidence comes in, right? So, it's where you get the file, review the documents, take a deposition, and potentially have testimony at trial. And so what could happen is you could have testimony at trial that then proves or establishes evidence of the negligence of the lawyer. Martin, am I saying all this correctly? Okay. And so the concern about allowing fees in this context, I believe, is that if there's some testimony at trial that, sort of clearly establishes that this person was not competent, you're really saying the lawyer should have made that conclusion, his or herself, correct? So there's there's an implication of error on behalf of the lawyer. Carl, is that why this is a thorny area, or are there other issues?
No, I think it's thorny, although I think the same type of issues can arise in a lot of other cases, right? Just basic contract cases, right? Could have similar competency issues. So I don't think it's unique to caveat proceedings. I don't know how this works. So y'all do this with the way that inquiries are made to the committee here. It does seem to me that it would be more beneficial to the bar as a whole if this was addressed not in the exclusive context of an estate matter, although I care a lot about that, right? But not in the context of an estate matter, but more generally. I think that would be interesting. I think it could help our profession, and I'm not just trying to help our profession to the detriment of clients, right? But I think it could be fair to include a provision like that. I also, though, think that there has to be something in there that says the attorney is required to make a judgment under section 1.7 or wherever it is to acknowledge that that the attorney won't be conflicted in any manner with regard to his client or her client. So I think that's an important aspect of that.
I have seen issues of competency arise, like with the execution of a deed of trust in real estate matters. So I've seen, for example, notaries sort of called as witnesses about whether someone had competency to execute a deed of trust. So there are issues that can arise in other contexts as well.
Right. So, and in the divorce context, and I'm not a family law attorney, but if somebody is presented with a family law agreement or a premarital agreement on the eve of the wedding, right? I think there are issues there too, and that anyway. So those kinds of issues pop up in a lot of different circumstances.
Martin, did you have anything else?
No, I'm sorry, I had to go take care of a client real
No, that's
quick.
okay. One of the things I thought I would just take the temperature of the room is we keep coming back to the same question, and we've got to start putting something on paper if we're going to do that, or decide we're not going to do that. So, we can either, right, I think, Suzanne, we can issue an opinion or decline to do that. Okay. And would anyone like to speak to whether or not you think we should issue an opinion or decline to do that in this scenario? And it's okay if you don't know yet.
Can I ask a question? I know when we submit private letter rulings to the IRS, so with apologies for being a tax lawyer, there's a dialogue that typically goes on where they will call and say, "Are you sure you want to ask it this way, or wouldn't it be more useful to you if we ask it in the following way?" I wonder whether there's the opportunity for the firm that submitted the inquiry either to amend it or for y'all to issue a opinion in a manner that's broader than what the specific firm requested, but I don't know the procedure.
We do have the ability to do that if we want to.
We can change the inquiry, but also we can do an unpublished opinion. We can do an ethics decision or ethics advisory just to the person that's asking the question. It would not become a published formal opinion.
So that would be our third option, an ethics advisory. So anybody else want to speak to that? Heidi, did you have something?
Well, I mean, I realized that the inquiry wasn't really submitted by a firm, right?
Exactly.
So
Yeah.
Was it submitted by Lawyers Mutual?
Yes.
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 Okay, yeah, I saw that thing you sent. And I know they keep coming and talking with us about the increase they see in litigation in our areas.
They did say one of their insureds had asked the question of them, but I agree, it's an insurance company.
So I didn't know if that changed the analysis of the options.
I don't think so.
Other thoughts about publish, don't publish, or do, we call it an advisory. I'm sorry, I always get the terms. Just what would be the opinion just to Lawyers Mutual, Suzanne?
Could either be an ethics decision or an ethics advisory.
Okay.
I'm pretty clearly in the camp that I don't want to issue an opinion on this. I'm pretty clearly in that camp, and I have been, and I think I still am. Martin, I want to ask one question. Why do you think lawyers should get a priority position in this space? Why should lawyers get treated specially in this space?
The idea would be to make me still want to do estate planning, to provide a public service of that to the public. It's kind of like a bank. Why does a bank want to lend money? Because they have a priority, because they get a deed of trust.
And the follow-on question is, are you going to stop if we don't endorse this?
No, I would not, but I
Yeah.
may have to raise my rates.
That's okay. Okay. All right, I'm sorry.
But I don't know that we're being treated specially, right? I mean, there are lots of contracts of adhesion that are presented to me every single day, whether it's from a bank or elsewhere, that says you're required to participate in mediation, you're required to participate in arbitration under certain terms, you agree to cover the rates. I'm talking about me as a human being, not as a lawyer. But I don't know. I mean, the question is, can we as lawyers, without violating an ethics prohibition, contract with our clients that they will pay us for those future costs? I don't think I don't know that we're being treated differently than anyone else. Maybe I'm missing something.
Are there a lot of lawyers out there that need an answer to this? I mean,
if we
But-
don't issue an opinion,
Yeah.
there's people using it and they'll just keep on using it.
I do worry that there are professional organizations like American College of Trust and Estates Council that are suggesting that this is an appropriate term to be included in sample engagement agreements, and that seems to me that that's creating a trap for the unwary that Lawyers Mutual is reasonably requesting be resolved so that it's not problematic.
That's why I guess I'm wondering if we're just, if we need to do this, and I hear what you're saying, Todd, but I'm just wondering if you've got Lawyers Mutual asking, and they've got all their insureds out there, and they don't know what to do, and they don't want to do anything unethical. And you've got people that are doing their estate. I keep going back to that. You got people that are doing their estate planning, and they want to make sure that when they leave this, go to the pearly gates, that what they wanted is going to happen. And if it gives them that kind of assurance, I don't know. I guess it's just a really tough issue for me.
Is there any empirical evidence out there as to how large of an issue this really is? I mean, I know we got it in the caveat space from Lawyers Mutual, but is there any evidence that this is really a big deal elsewhere?
Well,
Is
I
there
guess
any
it
evidence
depends
of
I think
that?
the issue would be our attorney. I mean, I just read off of another attorney's website. I mean, if lawyers are including this in their engagement agreements,
Yeah,
I think that would be the issue, right?
Is this North Carolina or another state?
ACTEC is a national conference.
You said you read it off of some lawyer's website.
Oh.
Is
I
that a
don't know the
lawyer
answer
in
to
North
that.
Carolina or in another state?
Yeah, I don't know the answer to that.
Well,
All right, let's go ahead,
we
Ashley.
know the state planning section of the Bar Association. Carl, are you the chair of that section now, or is that?
No, not of the section, just of the ethics committee, which normally is inactive. I get to read, what decisions you all have made in a given year, and to the extent that they're pertinent to the estate planning field. So like a year ago, you passed something on having to do with the sale of someone's practice, and we talked about it for about 3 minutes in a council meeting, and that was it. So normally, thank you very much.
God is big.
You just sit there and
Go ahead, Marcy.
What I'm saying is, would it be, before we make this decision, would it be, should we at least check with the estate section of the Bar Association and ask them, find out, is this a big issue? Is this something that they, I just guess, I know that I just this morning was looking at my employment agreement, and I've got some questions about, look for the recent ethics opinion that just came out. I'm trying to make sure that I'm doing what I'm supposed to do. I don't do estate work, but if I was an estate attorney, if I was, Martin or others, I would want to make sure that if I'm putting this in my agreement, that it's not going to come back and bite me and later, because I did something wrong and I didn't know I was doing something wrong. So, I don't know that we should kick the ball down the road if it really is a serious issue that needs to be addressed. To your point, Todd, I don't know.
We don't
I don't know how
know.
big of an issue it is, but I think we ought to at least do some due diligence to find out if it's something that's important. And that's a large, section of lawyers, the estate
agree.
planning lawyers.
That's what I was going to say. It's one of the biggest sections. I actually
Yes, it
work
is.
with Ellie Foy. She's one of my partners. And And,
I'm working with several right now, estate lawyers in a domestic cases. I mean, I could ask them, you know, I just feel like maybe we need to do a little more due diligence to see if it is.
I would be happy to run up the flagpole to find out. It looks like this provision was added to the ACTEC sample engagement agreements. I think it looks like it was added in 2017. I'd be happy to find whatever committee reviewed that and did it and why it was initially added. And perhaps it's more active in states like New York and
I'm only interested.
California, where there's maybe more
I'm only
litigation.
interested in North Carolina, but just I don't mean to cut you off, but I'm really just interested in what
Yeah,
the
okay.
lawyers in our state are wanting or needing from the state bar to make them feel comfortable about what they're doing. If they're trying to comply with ethics and trying to do the right thing, I want to make sure that they feel comfortable that they're okay.
Well,
But
the other thing I want to say, you said this, Suzanne, if this is really something that's already happening in like bankruptcy areas and other areas, and I'd like to know a little bit more about that so that, because I suspect whatever we do, other practice areas are going to say, I should be able to take advantage of the same rule that they just put in place for the caveat. So,
Yeah,
I mean,
I see that. You know, maybe check with the bankruptcy section to see whether I don't know. I'm just saying.
we
I
need
don't
to check
know
with a
that-
bunch of sections.
I have a couple ideas because it's 1 o'clock. So if everybody could maybe just give us
Yes,
4 more
ma'am.
minutes, so maybe we could do a little wrap up. I think what I'm hearing is some of us are still not sure whether we should publish an opinion. We feel like we might need more information. So I would propose that we do what we've just discussed, which is that we get some feedback from folks about how often these issues are arising and if they are already using provisions in their agreements. If they are using provisions in their agreements and they're willing to share this with us without fear of some type of action being taken against them, it'd be nice to see what they're using and what they're saying. But I don't know, Suzanne, if we can promise folks that if they provide something to us and there's something problematic about it, that we can't take action. So, you know, I just want to be careful about that. But getting a little bit more information, I think, would be a good idea. I'd also propose that we try to draft something to look at that might encompass some of the things that it looks like we might have some agreement on, so that we can at least get something on paper, even if it's something that none of us like.
Can I just-
And I'm not even necessarily in favor of publishing an opinion, so I'm not trying to forecast that. But I am saying we could try to do that and then just take a look at it and see what we think. Suzanne?
I was just going to say, as far as talking to the different sections as to whether this is a problem, I think that we heard that it's really a huge problem, the amount of time and money that some of these planning and estate lawyers get put on the hook for. So I think that has been established that that is a huge problem. But I think what we want to know is how many of them are using provisions like this. Is that the question?
I mean, it would be interesting to know if folks are and sort of what types of things they think they're able to put in the letters. But I think I also heard a desire to know, you know, how much does this come up in bankruptcy, family law, and other areas? Is that right?
I'll be right there.
Well, first of all, if you go to seminars, estate and planning seminars, I know at family law seminars, they give us ideas of what you should add to your PMAs or to your property settlement agreements, and we're always constantly talking about things like that. I mean, are they talking about this at in their seminars? Are they talking about this issue and this problem? Have they discussed whether or not to put these type of provisions in their retainer agreements or not? I mean, I think you just go to I just would like to know.
Can I speak for a second? As to the bankruptcy section counsel, I just rolled off and I have not seen these anywhere. I was subpoenaed this past year for the first time and did not charge. The response was turned into my malpractice because there is a provision in our coverage that
Right.
an attorney was appointed, but I did not charge for my time. So I'm not familiar with any bankruptcy. That doesn't mean there aren't any, but I haven't seen any in the fee agreements for what it's worth.
And I think Stacy's making an important point that if you're insured, most liability insurers will provide some coverage to the lawyer for this. And so, you know, the lawyer, well, they'll at least provide, I guess, counsel, but you weren't compensated by your insurer for your time, Stacy. Is that right?
Correct. And it did I kept track of my time just since I was on this committee and, you know, we've been talking about it. I mean, it was a few $1,000s and I didn't testify. I just produced documents, but it did take a while. And so I haven't heard of anybody being compensated in that situation. There were 5 of us that were subpoenaed in this case. It involved a NASCAR sale of a NASCAR team, and everyone had counsel, separate counsel, and to my knowledge, no one was compensated. So,
Right.
And I'm going to have to.
I'd also
sorry.
like to say that not all estate planning lawyers are, making tons of money. I mean, you do still have small town lawyers that do estate work, so I think there was a comment earlier from somebody that, oh, well, all these estate lawyers make tons of money and they just jack up their rates and blah, blah, blah. Well, that's not necessarily the case. Again, in the smaller rural, Martin's smile there, in the smaller areas, we're not talking about just Charlotte and Raleigh and, the Wilma Carlisles of the world. There are in these small towns estate planning lawyers that people go to because they know them from church or they know them from somewhere. So we're not talking just about the ivory tower lawyers, doing this stuff. We're talking about the smaller towns. Do they, and a couple of $1,000s is a lot of money to them. Be pulled out of their office, and they've got money and everything. So I mean, I just think we just need to think about it a little more. That's all I'm saying.
Wade, did you have anything? Because I've not heard anything from you today. Just want to make sure you have an opportunity to contribute if you'd like to.
I think this is probably something that if the word gets out that somebody's using this provision, it's going to be adopted it's going to be like flames through the dry grass. In fact, Heidi and I have been talking about it. I'd like to put it in my agreement. And we have premarital agreements that are frequently litigated. And you get dragged in for that. And it's not a lawyer's mutual deal. It's just that they want a witness to what was going on contemporaneously when the thing was entered. So if we don't have an opinion about it, I'm probably going to draft a provision and put it in my fee agreement. And depending upon the sort of the temperature that we get in on this committee, I may or may not submit it to the North Carolina State Bar for approval. I may just ask for forgiveness if they decide, somebody wants to push it. But I don't see this as a public protection issue. I don't see it as favoritism to lawyers. I think it's a necessary thing because of our litigious society. That's it.
I was just going to point out the 2 ethics opinions that I included with the materials that are talking about lawyers being subpoenaed and responding to subpoenas. I don't think they're in the domestic area, but there's an ABA opinion and a New York opinion, and basically they just offhandedly say, lawyer, you might want to put something in your retainer agreement that says you're going to get paid if you get subpoenaed. So
yeah, and I talked to Suzanne about this before the call, and I said, if we wrote an opinion, something very clean is if there is a subpoena, then you're entitled to recover the fee. Because as a lawyer, you can demand the subpoena. You say, I'm not going to produce this unless you give me a subpoena. Then it creates a very clean scenario where the rule kicks in. So that's just something I think to think about. If you don't have a subpoena requirement, it gets really vague.
Well, actually, if we
I
did
don't
a
think you
subpoena,
should give it without a subpoena. First of all,
Yeah, right. I agree. I agree.
if you have like a bright line subpoena, then of course what Todd's worried about is the application of this to everything as opposed to just this one area.
Well, and I mean, maybe that's okay.
right.
And maybe that once we have the subpoena in there, then that opens the door for us to be able to utilize this in our fee agreement.
Hey,
So that's why I
Suzanne,
think we should play around with drafting some stuff and just
maybe-
look at it. And I think we should pull together all of these provisions that we've been talking about, sort of get those on paper so we can see what is currently allowed. I don't know. I just think I'd need to sort of look at some things. I don't know how you guys feel.
Last point for me, if we're going to go down this road, there are statutes, as you guys know, which address how much you're paid if you're subpoenaed, and it's nothing. And so those are statutory requirements that we'd have to overcome if we put something in here that basically if you're on a subpoena, you get $5 plus mileage per day. I mean, so that's the law in North Carolina right now.
That's not going to help then.
I'm saying, but it
Yeah.
is the law.
Uh,
The
Can I ask
statute is what it
everybody-
is.
Can I ask everybody to send every provision that you think might be applicable to Suzanne, so that she can put them in a memo for us?
And again, the question is, can that be overridden, Scott? I mean, tie with in a contract or,
Correct. That's right.
Yeah,
Wonder
then
if
we
you
can
get-
look at them.
I'm sorry, I did find another case that said that even though there's a statutory allowance, if you're subpoenaed of like what, $3 or something, that you can,
Contract.
you can contract for your client to pay you
Okay.
more.
So let's look at
It's not a
that.
North Carolina case, but
Yeah,
it
let's
is.
look
I
at
mean,
that, because that's
I think-
usually you can enforce contracts that are contrary to our law, so you guys.
It's
know
just
that.
saying that the client agrees, the client knows that that's what you're allowed by statute,
Got it.
and the client agrees that
That's
they're
the
going
form.
I
Yeah.
got it. Okay.
to more.
contractual.
So I know it feels like we've not accomplished much, but I think we have actually. I think, so what we're going to do, just to summarize, we're going to get a copy of sort of all these provisions that we think currently exist in one place so we can look at them. We're going to do a little bit more investigation, and Carl's going to dig around a little bit too, to sort of better understand the scope of the issue. And we might draft a little something.
Carl's gonna block my my
Oh,
phone.
and Elsie, when you say provisions, are you talking about provisions like that's in this AgTech agreement?
No, I'm sorry. I'm talking about like existing statutes,
Statutes.
evidentiary rules, rules of civil procedure, et cetera, that allow for the recovery of fees under certain scenarios.
Right.
I feel like I personally, as a member of the committee, need to put my eyes on them. I'm a little confused
Right.
about some of the discussion. I think that might help us get just sort of grounded in what currently exists and whether we need anything else.
Well, like, for example, Martin, I usually he seems to know what he's talking about, but, we have a case where somebody's trying to set aside an irrevocable trust.
mhm,
And the estate planning lawyer is being pulled in.
mhm.
Can they charge for that? The one that drafted the trust.
Yeah,
That's what we're
the question.
talking about, because they could be a fact witness at this point, and they're
Right.
getting pulled in. And so it takes the time, and that's the big question is, okay, well, can they? And in the situation I was going to tell you all about as well, I was on the creditory judgment, it was an action between siblings. The state was tangential to it. So, but yet you'd have to pull in the estate drafter as far as who did the work, because the grandmother consulted with an attorney and was in essence trying to get a will done before she died. Does this give some sort of an intent? Well, now who gets to bill for that? Because it's clear. It's hard.
But isn't this limited to if it's in the retainer? I mean, this is a more narrow issue here. It's not all these other things that we all deal with every day. But I
But-
mean, we're talking about
But the
this.
question comes, can we put it in the retainer?
Right.
Well,
That's
well,
the
right.
issue. We're not really here. I've got cases now where trust attorneys brought in. We got 2 or 3 of them in our domestic case right now. That doesn't apply to what we're talking about.
That's right.
This is a more narrow inquiry.
The hope.
Put it
We
in
hope
your-
it is.
True, but I was only saying, could it be a slippery slope, right? I mean,
Yeah, oh, yes.
Yes,
yes.
Well, I
yes.
mean,
I think if we say they can do it, I don't think it's going to be limited.
Mm-mm.
dude, you talking about to estate.
Anybody.
That's right.
It'll be, Katie brought
Practice
it where
any
everybody's
practice
going.
areas.
Yeah.
I'd like to see it I'd like to think about it in the context of when there is a subpoena. That would be a slightly more narrow situation.
I think the actual provision for AgTech is narrower than that, right? It says if a firm is deposed, called to testify, or required to respond to discovery in the context of legal proceedings. I think that's even past. That's even past. I mean, if I get a subpoena, lawyers may be firing at each other and trying to get people involved. Just because I receive a subpoena doesn't necessarily start the clock, right? But I think it's those specific things that are more time consuming is what this is covering.
But
And
as
it could be both things. It could say receive a subpoena and you're
Yeah.
deposed, called to testify, respond to discovery.
But as a non-party, you would have to receive a subpoena in every one of those situations to compel you to participate, right?
I think
That's
that's right.
That's right. And you can object like heck. I mean, you say,
Right.
Right. Okay, thank you, everyone.
It was
Really
nice to meet you.
Thank you, Suzanne.
Thank you, Carl, so much.
Thanks,
So
guys.
much.
My pleasure. Thanks for the invite, Suzanne.
Thanks.